Welcome to week 11, and this week we're focusing on accommodating the needs of the digital reader. Now you might be wondering why we need to do that in this unit when we're primarily focused on honing your legal drafting skills in written documents. And there are two primary reasons for this. The first is that so much information is provided in legal practice in this manner. So it's provided in electronic format for you to read on a screen. So for example, emails, pleadings, affidavits, written evidence, documents that you're required to review and amend, all of that takes place in the context of being on your computer and on a screen. And of course, if that's happening to you, it's also happening to your opponent. Most of our legal research is actually also carried out online. We will look for cases online, then we will download the cases and usually view them on screens. And what of course that means is that you end up with really bad eyesight. So it certainly happened to me. So please make sure that you do take regular screen breaks. Now, aside from the impact that this has on our eyes, one of the primary things that we need to remember, so this is the second reason for looking at this, is that screen reading impacts the way that we read the material and absorb the material. And of course, we need to accommodate our drafting to make sure that the reader absorbs the maximum possible from what we've provided. Now, as discussed in effective legal writing, our eyes move through the material on screen in a very different manner to which our eyes will move through a written document that we're holding in our hands. So there's more of a zigzagging effect when we're looking at material on a screen. Often we're scanning for information and trying to put that scanning into context to understand the whole of the document, whereas we tend to read line by line when we have written documents in our hands. Of course, that means that we're often slower at reading written documents, but we're also more careful and more comprehensive in our review of the material. So we need to be mindful of that when we're drafting any material that is either designed to be read on the screen or is likely to be read on the screen. One other important reason for looking at digital documents and the way that the information is communicated through that medium is because law firms increasingly are resorting to digital mediums to communicate with potential clients. In so doing, they might use a website or a blog or social media platforms like Facebook and Twitter to communicate with potential clients and market their services. It may therefore be the case that you're asked to, say, write up about a recent High Court case or promote the services of the law firm through one of those digital mediums. So understanding the needs of the digital reader and how they might read the information and absorb it is therefore critical to achieving whatever the task purpose is. So let's first look at drafting for a web page, a blog, or social media platform. Let's look at that sort of digital context. So what we're about to discuss is relevant to your own personal web pages, blogs, and social media accounts, as well as those of your firm. And we're going to start off first with a warning. When we're engaging in mass communication through these mediums, we need to be very careful about the types of comments that we present, and particularly the comments that you make. As you'll be aware from studying torts, defamation may occur through online comments that others view or read. And now, following that very recent High Court decision of Voller, you or your firm may be liable in defamation as the publisher of another person's comments on your Facebook page, YouTube channel, or other social media account. That means that you and your firm need to very carefully monitor what others post on those accounts, on your walls, etc. And be careful that you do not retweet, repost, or like defamatory material. So in essence, if you are in control of the information, so through your account you can delete comments, for example. If you are in control of the information, you may actually be liable for comments that other people make. So we need to be very careful about how we navigate social media platforms and blogs and other web pages where we're engaging with others or where we are presenting information to the world. Now, you may recall the case of Burroughs and Haldra, in which it was determined that even emojis could potentially be defamatory if they conveyed something to others about the complainant's reputation. Now, in that case, the defendant retweeted a newspaper article from the previous year, and in that newspaper article, the newspaper discussed a judge's recommendation that a lawyer be referred for disciplinary action. Responding to comments on that retweet that had inquired about whether or not the lawyer was subject to disciplinary action, the defendant didn't reply but just posted a zipper mouth emoji. At an interlocutory hearing, the judge determined that the emoji was potentially capable of conveying the imputation that the lawyer had been subject to disciplinary proceedings with an adverse outcome. So we can see from this case that it's possible that even emojis and symbols can be regarded as defamatory. So we need to be very careful about how we engage in instantaneous communication, particularly through social media platforms, but even in messaging, because as lawyers, these issues can come back to haunt us. Aside from defamation, there are a range of professional conduct issues that may arise in relation to your conduct online. Many of the law societies across the states and territories have provided warnings and also guides to lawyers to help them navigate the online world. Now, one of those warnings that we frequently see in those guides is to ensure that you do not engage in bringing the profession into disrepute through your online communication and online conduct. So, for example, referring to other members of the legal profession or judges or administrative staff in the courts or other law firms or clients in a derogatory manner may fall within that concept of bringing the profession into disrepute. Now, with these warnings in mind, how can we adapt the content on our web pages, blogs, social media platforms, or documents that are likely to be read on the screen to meet the needs of the digital reader? Now, as I've already previously mentioned, we read documents on a screen quite differently to how we read documents that we hold in our hands. According to Liu, we tend to scan for keywords and therefore a passage of text will be read in a sort of zigzag fashion rather than reading line by line. So, for example, if you're trying to engage the audience in a blog, you really want to avoid large chunks of text because the reader is much more likely to scan for context, and therefore the reader is also likely to miss information that you have presented. So in that situation, you would want to keep your paragraphs very short and to the point so that the reader is more likely to read the entire section rather than scanning for content. So the more densely packed the information, the less likely the reader will read it line by line, and the more likely the reader will scan and therefore miss bits of information contained in that densely packed paragraph. As effective legal writing notes, you should also consider whether the information can be presented in a more visually appealing way. So what we mean by that is, could you present statistics, for example, in a table or a pie chart or a graph? Consider whether it would help the reader to visually represent the information that you're discussing. It is much more interesting for a reader to see, say, prosecution rates in relation to a particular offence in a visual format rather than just reading about it in a large, long paragraph. For inspiration, I suggest that you have a look at the Information is Beautiful website, and that shows how very complex statistical information can be presented in a really visually appealing way. Beyond the basic graphics and visual representations of information, we're actually starting to see some really innovative approaches towards conveying really complex legal information. In Effective Legal Writing, we discuss the Oricon comic book contract, which features in case study 7.3. But there are also a range of other comic book style contracts that are out there, including ones for terms and conditions for banks. And you can see those at comicbookcontracts.com, so make sure you check those out. You could also have a look at the Street Vendor project, which focused on designing information for street vendors concerning the regulations that governed where they could have their food carts. And the focus of that project was to ensure that the information could be presented in a way that was easy for street vendors to understand. So we're starting to see a real focus on the design of the document so that the information is presented in the optimal way for the digital reader. Now, often that digital reader is a consumer, but not always. But really, I'm challenging you to stop and think about the information and how it's presented before you just go straight to writing basic text into those digital documents. Now, you should also aim to avoid as many distractions as possible in your writing. In the online world, there's lots of competition for the reader's attention. There can be things such as pop-up windows, boxes, push notifications that draw the reader away from what you have written. Now, those are outside of your control and often difficult to avoid. But there are some distractions that you can control. You can mitigate the extent to which the reader might be drawn away from what you've written. So one of those main distractions is hyperlinks. Hyperlinks to materials are useful because they enable the reader to go to the relevant source and thus gain a better understanding of the content if they want to. But they can also draw the reader away from what you've written, and they might never actually return to what you had written and stay on that page or even go down further rabbit holes. So I'm not saying don't ever include hyperlinks. It's actually probably impossible when you're trying to give comprehensive information to the reader. So in legal drafting, I've provided you with links to other sites where you can view information that's relevant to that particular task, such as court forms, for example. So I'm certainly not saying don't include them, but there are two things that you can do to minimize the effect that a hyperlink might have on the reader. So the first is, of course, to consider whether you really need to include it in the first place. Secondly, assuming that you do need to include it, carefully think about where you place it within the text. So if possible, hyperlinks should be at the bottom of the text, at the bottom of the document. For example, if you were writing a case note about a new High Court decision for a blog perhaps, put the case name in the body of the text, but don't provide the hyperlink there. Then have a list of references at the bottom with the hyperlink to where the judgment can be located for free on OSLI. That way, the reader is much more likely to get through the material that you've written before they take the hyperlink to a different web page. Now, the final thing that I wanted to discuss with you today is email, and this is a common pitfall for law students. We're so used to messaging quickly in a range of apps on our phones that we often treat email in the same way as other forms of instantaneous communication. But we need to be very careful in all of our communications, including those at university as well as in law firms. And we need to be careful in email, Moodle forums, MS Teams. In all of those cases, we need to make sure that we're professional and courteous at all times. Not only is this relevant, of course, to the student charter, but it's also good practice for being a lawyer. There are professional conduct issues associated with adopting a disrespectful, rude, or aggressive tone in email or other forms of instantaneous communication, just as would be the case in a written letter. Now, even if someone sends you a rude email, you need to take some time away from the email before you respond so that you can calm down and approach it with a level head. And that's assuming, of course, that a response is even needed. So take some time away from it. Don't respond quickly. Consider whether you need to respond at all. And if you do, make sure that you carefully plan what you're going to say and you maintain that professional courtesy at all times. Now, once you're in practice, the temptation will be to fire off emails as quickly as possible because you're doing lots of different things on lots of different files and you feel time poor. But professional obligations arise in this context just as they do in the letter writing context. Under Clause 4.12 of the Australian Solicitors' Conduct Rules, lawyers must be courteous in all dealings, and the confidentiality obligations that we explored in relation to letters, and tactical issues around what you should and shouldn't reveal to the other side, and the obligation to avoid making false statements to the other side apply equally to emails as they do to letters. So we need to be cautious in the drafting of emails and other forms of response. Now, in relation to emails specifically, Effective Legal Writing has 10 top tips, which I urge you to read. Most of them you can start to apply now. They're not legal profession specific. They are actually designed for you to think about how you are communicating with others via email, both in the student and legal profession context. So you're certainly going to be developing some good habits for legal practice if you start observing those 10 tips now. However, for most of us who are time poor and in a world of instantaneous communication, I think the most important thing that we can do right now is to carefully construct and comprehensively review what we've written before we send it. That is the primary obligation of you as a law student and lawyer. Construct it carefully, comprehensively review it before you send it. I feel that as instant messaging has become a normal part of our daily interaction with others, and more so in the COVID pandemic, we tend to now opt for speed over precision. And this can impact on the reader's perception of your professionalism, the quality of your work, and it also affects how they might respond to you in future. It can also lead to the misrepresentation of information or misinterpretation by the reader. So that can be problematic for both you and your client. So again, in that online fast-paced world, slow down, construct carefully, review, and then send. Now, in the workshop this week, we would like you to look at a web page or a blog or a wiki page that has online content that's related to the law, and we'd like you to identify the ways in which that material might be improved to assist the digital reader in navigating the content and absorbing the information presented. So I'm very interested to see what sites and comments you come up with in the workshop. So I'll see you then.